So picture a lone individual walking up those sprawling concrete steps of a federal courthouse,
Right.
and they're entirely unrepresented. I mean, there is no lawyer in a sharp suit walking next to them, no customized leather briefcase, just a regular citizen armed with nothing but a stack of papers they probably printed themselves at the local library.
Yeah, just walking right through those metal detectors.
Exactly. And they're going up against an entire city's legal department. And usually, when you hear a story with that kind of setup, the classic David versus Goliath dynamic playing out in the modern justice system, it ends quickly.
Very quickly.
Right. And it ends in just crushing, unceremonious defeat.
Oh, absolutely. I mean, it is a procedural slaughter.
Hmm.
The federal legal system is an incredibly complex, unforgiving labyrinth.
Yeah.
So those unrepresented individuals, no matter how justified their underlying grievances might actually be,
Yeah.
they usually get completely lost in the maze of procedural rules before they even reach the inner courtroom doors.
But the case we are looking at today breaks that mold entirely. Today, we are taking a deep dive into the civil rights complaint of a case called Rouse v. City of Reno.
A fascinating case.
Yeah, it's a federal lawsuit brought under 42 U.S.C. Section 1983. And if you look at the trial scripts, the filed complaints, and the academic journals covering this area of law, you realize this isn't just a legal battle. It's really an attempt to pull off a statistical impossibility.
Right, and our focus here is on the specific architecture of that attempt.
Yeah.
Because we are going to examine how this plaintiff uses source documents, including an exhaustive manual audit of court records and a very recent, highly explosive firing of a police chief to strategically bypass the traps that usually destroy these cases.
I mean, the sheer amount of meticulous preparation this plaintiff has done is staggering.
It's really staggering.
But, why should you care about the mechanics of a single civil rights lawsuit in Nevada? Well, because cracking this specific case decodes the secret language of the American justice system. It reveals the exact mechanisms cities use to shield themselves from liability. And it shows how an ordinary citizen with enough determination and, frankly, some perfectly timed local scandals might just be able to pick the lock.
Well, I do appreciate the lock-picking analogy, but we really have to ground this in the harsh reality of federal jurisprudence.
Fair enough.
Because enthusiasm and determination do not win federal lawsuits.
Right.
Specific, rigorously applied legal mechanisms do. So we need to weigh the sheer statistical improbability of a pro se victory. That is, a self-represented victory against the highly unique and devastating facts presented in Rouse's complaint.
Right, because we can't appreciate the brilliance of his strategy until we understand the baseline odds he's up against.
Exactly.
So let's establish that baseline then. When we talk about the statistical graveyard of pro se litigation, what kind of numbers are we actually looking at?
The numbers are sobering to the point of being deterrents, honestly. We have comprehensive data from the Federal Judicial Center alongside this massive multi-year study from Cornell Law School. And when a plaintiff chooses to represent themselves in federal court, they lose roughly 80 to 90% of the time.
80 to 90%.
Yeah.
So right off the bat, you have, at best, a 1 in 5 chance of just surviving the process.
Well, it's actually worse than that.
Wait, really?
Yeah, because just surviving the process doesn't mean winning. To put a finer point on it, pro se plaintiffs receive favorable final judgments, meaning they actually win their case on the merits or receive a settlement that favors them only about 3% of the time.
Wow. 3%.
Right. Now, contrast that with plaintiffs who have legal representation. Represented plaintiffs secure favorable judgments roughly 40% of the time.
That is a staggering disparity. 3% versus 40%. I mean, it really paints a picture of a two-tiered justice system based entirely on whether you can afford the admission ticket of a lawyer's retainer.
It does. And the most dangerous phase for these pro se litigants isn't a dramatic trial in front of a jury. It is the very beginning of the lawsuit.
The paperwork phase.
Exactly. We are talking about the motion to dismiss stage. So under Rule 12b-6 of the Federal Rules of Civil Procedure, a defendant can file a motion arguing that even if everything the plaintiff says is true, it doesn't amount to a valid legal claim.
Right.
According to the data, over 56% of pro se complaints are dismissed at this preliminary stage.
So over half are tossed before they even leave the starting line.
Yes. They never make it to discovery.
And discovery is the big one, right?
It's the crucial phase. That's where a plaintiff gets the court's authority to demand internal documents, emails, and sworn depositions from the defendants. If you are dismissed at the motion to dismiss stage, you are locked out of discovery forever. You certainly never get anywhere near a jury.
I was reading through our sources, and I noticed this really fascinating piece of data regarding artificial
Oh,
intelligence.
the generative AI study.
Yeah, because if you look at the current tech landscape, you'd think things like ChatGPT and generative AI would be the ultimate equalizer for self-represented plaintiffs.
You would think so.
Right, like you just feed your story into an AI, tell it to write a federal civil rights complaint, and boom, you have a professional-sounding document.
You would certainly hypothesize that.
Yeah.
But a recent study we reviewed, it's titled The New Pro-C Generative AI, and the surge in federal civil self-representation,
Yeah.
it tells a completely different story.
How so?
Well, the researchers analyzed federal civil filings in the years before and after the widespread public release of generative AI tools. They found that the rate of pro-se plaintiffs surged significantly. It jumped from 11.33% of all federal filings to 16.94%.
Okay, so a lot more people trying it.
Right. That represents roughly a 50% relative increase in people trying to sue on their own.
So people are definitely feeling emboldened by the technology. I mean, they're rolling the dice more often.
They are. But the win rate didn't budge.
Really?
In fact, for complaints that were flagged by the researchers as being assisted by generative AI, the favorable outcome rate was a dismal 3.7%. Yeah, and for unflagged, traditionally drafted pro se complaints, during that exact same period, it was slightly higher, at 5.3%.
Wait. If an AI can write a flawless, grammatically perfect legal brief, why isn't it moving the needle? I mean, is the court heavily biased against AI-generated documents, or is the AI just fundamentally failing to understand the actual law?
Is the latter.
Yeah.
This system is entirely immune to simple technological shortcuts.
Interesting.
Yeah, an AI can generate a document that sounds incredibly authoritative.
Okay.
It can use terms like hereunto and whereas.
Typically, it sounds like a lawyer on TV.
Exactly.
Yeah.
But AI models are essentially highly advanced predictive text engines. They do not possess substantive legal reasoning.
Right.
They often generate what we call legal hallucinations, citing cases that literally don't exist. But more importantly, they fail to weave raw, specific facts into the stringent doctrinal requirements of federal law. They write beautifully worded conclusions, which, as we will see, is exactly what gets a case thrown out.
So why do human pro se plaintiffs fail so consistently then? I mean, is it because they're all filing frivolous, baseless lawsuits?
No, and that is a very common misconception. It's often not because their underlying claims are false or their grievances aren't real.
Okay.
It's because they failed to meet the incredibly strict procedural and substantive pleading standards of the federal courts.
The rules of the game.
Yes. The legal system operates on a highly specific, almost mathematical set of rules. If you do not construct your complaint using that exact structural language, your case is dismissed, regardless of the objective truth of what actually happened to you on the street.
Okay, let me see if I can visualize this. Is navigating federal court like try and play professional tennis, but you only have a ping pong paddle? Like you just lack the right equipment because you don't have a law degree?
That's a good start. Yeah.
Or is it more like showing up to a tennis match, but you don't even know the rule? Like you don't know you have to serve from behind the baseline, so the umpire just disqualifies you immediately?
It's an interesting analogy, but I would actually complicate it even further.
Okay, lay it on me.
It's not just that you lack the equipment, and it's not merely that you are ignorant of the rules. Imagine showing up to that tennis match, but the governing body of tennis recently decided to change the fundamental laws of gravity on the court, specifically to make it harder for anyone to score a point.
Oh, wow. They changed gravity.
Metaphorically, yes. The courts actually shifted the baseline requirements of how a lawsuit must be written, which brings us to the evolution of pleading standards.
The twin pillars of doom.
A dramatic moniker, but apt. To understand the wall Rouse is up against, you really have to understand how pleading standards shifted.
Okay, how did it used to be?
Well, for about 50 years, federal courts operated under a very permissive system called notice pleading. This was enshrined in a 1957 Supreme Court case called Conley v. Gibson.
Notice pleading.
Right. Under notice pleading, all a plaintiff really had to do was give the defendant fair notice of what the claim was and the general grounds it rested upon.
So basically just saying, hey, you fired me because of my race and I'm suing you for it.
Precisely. It was a very low bar. The Supreme Court in Conley explicitly stated that a complaint should not be dismissed unless it appeared beyond doubt that the plaintiff could prove no set of facts in support of their claim.
That sounds incredibly fair.
It was. The underlying philosophy was democratic, let people get their foot in the door, let them get into discovery, and let the actual facts dictate whether the case survives.
So what happened? Why did they change it?
The Supreme Court dismantled it. Over two major decisions, Bell Atlantic Corps v. Twombly in 2007 and Ashcroft v. Iqbal in 2009.
Twombly and Iqbal.
Yes. These two cases completely threw out the Conley standard of notice pleading and replaced it with what we now call the plausibility standard.
Plausibility. Okay, so if I'm a pro se plaintiff writing my complaint at the local library, what does this plausibility standard actually mean for me?
It means you have to pass a brutal two-step test created by the Iqbal decision. When a judge looks at your new lawsuit, they must perform step one, which is identify and ignore any conclusory statements.
Wait, what exactly qualifies as a conclusory statement?
A conclusory statement is essentially an assertion of a legal conclusion disguised as a factual allegation.
Give me an example.
Sure. For instance, if you write, Officer Smith acted unlawfully and with deliberate indifference to my rights, the judge is legally mandated to take a mental red pen and cross that entire sentence out. It does not count towards your case. You cannot just state the ultimate legal element you are trying to prove.
That seems really counterintuitive. You can't state the very thing you're suing them for.
Well, you can state it, but it carries zero weight.
Right, okay.
Then comes step two. The judge looks at whatever specific, granular, concrete facts are left over in your complaint after they've crossed out all your conclusions.
Just the raw facts.
Exactly. Those remaining naked facts must prove that your claim is not just conceivable or possible, but plausible on its face.
Plausible on its face.
Right. The Supreme Court said judges must use their judicial experience and common sense to determine if the facts show a reasonable likelihood that the defendant actually committed the misconduct.
But wait, and this plausibility test happens before discovery, before you can demand any emails, body cam footage, or internal memos from the city.
That is the crux of the issue. That right there. You have to prove your case is plausible using highly specific internal facts before you are allowed to use the court's power to go find those facts.
Which brings up a massive critique we have in our source materials from the American Constitution Society. They call this an informational asymmetry.
Yes.
I mean, let's think about this logically for a second. If you are a victim of police misconduct or employment discrimination, how on earth are you supposed to plead highly specific internal facts about the government's secret motives or unwritten department policies if the government holds all of those documents under lock and key?
You've identified the exact structural tension. The American Constitution Society, along with numerous legal scholars, argues that Twombly and Iqbal created an insurmountable catch-22 for civil rights plaintiffs.
A total catch-22.
Right, because you need concrete facts to get into discovery, but you need discovery to get the concrete facts. And the data reflects this reality. Following the Iqbal decision in 2009, the rate of motions to dismiss being granted by federal judges just skyrocketed, particularly in complex civil rights and employment discrimination cases.
So if this plausibility rule applies to everyone across the board, both represented plaintiffs and unrepresented ones, why does it disproportionately slaughter the pro se cases?
Because lawyers are specifically trained to reverse engineer complaints.
Ah.
They know how to weave raw circumstantial facts into a narrative structure that checks the specific doctrinal boxes required by the Iqbal standard without relying on conclusory language. Self-represented individuals, on the other hand, fall into a very understandable, very human trap.
They write emotionally.
They do. They have been wronged. They are angry, they're traumatized, and they're seeking justice. So they write broad, sweeping, emotional accusations.
Like a manifesto.
Basically, yes. They will write something like, the entire police department is corrupt, they conspire to ruin my life, and they violated my constitutional rights.
And to a normal person, that sounds like a lawsuit.
But to a federal judge bound by Iqbal, that entire paragraph is conclusory. The judge legally must ignore it. And once you strip away the emotional rants, the broad claims of corruption, there are usually no concrete specific dates, times, and actions left over to make the claim plausible.
So they pour their hearts out onto the page, and the legal system acts like a robot saying, does not compute, claim dismissed.
Pretty much.
Okay, so we understand the pleading standards are incredibly strict. But the case we are analyzing today, Rouse v. City of Reno, introduces an even higher mountain to climb, because Rouse isn't just suing an individual police officer. He is suing the city of Reno itself.
Yes, and suing a municipality introduces the most complex, most fiercely defended doctrine in all of civil rights law.
Monell.
Monell. Let's unpack the Monell doctrine, because Rouse's lawsuit is filed under 42 U.S.C. Section 1983. So if Section 1983 allows you to sue state actors for violating your rights, I assume Monell was the Supreme Court case that finally allowed citizens to sue the city itself.
That is correct, but with a massive structural caveat.
Yeah.
To give some brief historical context, Section 1983 was originally passed as part of the Ku Klux Klan Act of 1871, and it was designed to give citizens a way to sue state officials who were violating their civil rights.
Right.
For a long time, courts held that you could only sue the individual officers, not the municipal corporation itself. Then came the 1978 Supreme Court case, Monell v. Department of Social Services.
What were the facts of that case? Like, what actually happened? So in Monell, female employees of the Department of Social Services and the Board of Education in New York City sued because they were being forced, as a matter of official city policy, to take unpaid maternity leave before it was medically necessary.
Wow, okay.
Right. And the Supreme Court ruled that, yes, a local government can be considered a person subject to suit under Section 1983.
So that sounds like a win for civil rights.
It was, but the court established a very specific limitation that has become the absolute bane of civil rights lawyers ever since. They ruled that a municipality cannot be held liable under a theory of respondent superior.
Okay, let's translate that. Respondent superior means vicarious liability, right? Like an employer is responsible for the actions of its employees.
Correct. In the private sector, vicarious liability is just the standard. If a FedEx driver runs a red light while on their route and hits your car, you don't just sue the driver, you sue FedEx.
Right, they have the deep pockets.
Exactly. The corporation is inherently responsible for the negligence of its employees acting within the scope of their employment. But under Monell, the Supreme Court explicitly rejected that for cities. You cannot sue the City of Reno simply because a Reno police officer violated your rights on the clock.
So if I'm walking down the street and a police officer unjustifiably uses excessive force on me, the city isn't automatically liable, even though they gave him the badge, the gun, and the paycheck.
Exactly. To hold the city itself financially liable, you have to prove that the constitutional violation was caused by an official policy or custom of the municipality. The government entity itself has to be the moving force behind your injury.
So if I can't just point to the officer's bad behavior, how do I actually prove that a whole city is responsible? Our sources, including an article from Tressler LLP, which is actually a guide written for defense attorneys on how to defeat these exact claims, they outline 3 specific pathways a plaintiff can use.
Right. There are essentially 3 ways to establish Monell liability. The first is an expressly adopted official policy. Now, this is rare today, but imagine a city ordinance that explicitly authorizes unconstitutional searches.
Like the forced maternity leave policy in the original Monell case that was written down?
Exactly. It's written down, it's official, and it's unconstitutional. The second pathway is proving a widespread practice or custom that is so persistent and permanent that it constitutes a custom with the force of law, even if it is not written down in any manual.
Okay, then the third.
The third is a failure to train, supervise, or discipline municipal employees that amounts to deliberate indifference to the constitutional rights of the citizens they interact with.
Proving any of those 3 sounds incredibly difficult.
Oh, it is.
I was looking at a study published in the Emory Law Journal by Professor Nancy Leong and her research team. They conducted an empirical analysis of federal civil rights complaints to see how well plaintiffs navigate this doctrine, and they found that 56.5% of complaints filed by represented parties, meaning plaintiffs who actually had law degrees working for them, failed to even state the basic doctrinal elements of a Monell theory.
It's astounding data.
Yeah.
More than half of licensed attorneys mess this up.
Yeah.
The study showed that lawyers were often just copy-pasting boilerplate, generic language into their complaints. They would write things like, the city had a custom of conducting unconstitutional searches without providing any underlying facts or historical examples.
Which,
as we just learned from the Iqbal plausibility standard, is a purely conclusory statement.
the red pens.
Exactly. The judge crosses it out and the Monell claim collapses.
I want to focus on that third pathway you mentioned, failure to train, because that comes up heavily in Rouse's case. How does a plaintiff prove that a city failed to train its officers?
The Supreme Court laid out the standard for this in a 1989 case called City of Canton v. Harris.
Okay.
The court established that deliberate indifference is a highly stringent standard of fault. It is not enough to allege that the city was merely negligent in its training, or that a particular officer was poorly trained, or even that a better training program would have prevented your specific injury.
So I can't just say, the officer who hit me didn't know the law, so clearly the training academy failed.
No. You have to prove that the city policymakers had either actual or constructive notice of a clear pattern of similar constitutional violations, and that despite knowing about this pattern, they consciously chose to do absolutely nothing about it.
Okay, going back to my delivery driver analogy, I sue FedEx if their driver hits me, but with the city under Monell, it's like I have to prove that the CEO of FedEx wrote a memo telling drivers to run red lights.
It's close, but to make it fit the Canton failure to train standard, it's more like this. You have to prove that FedEx management received 100 reports over the last 2 years that their drivers at a specific facility were running red lights and hitting pedestrians.
Okay.
You have to prove management read those reports, knew the drivers lacked basic traffic safety training, and deliberately chose not to institute any training to fix it.
Wow.
Only then, when the 101st driver hits you, can you hold the company liable for deliberate indifference.
That requires an impossible amount of inside knowledge. I mean, how is an ordinary citizen sitting at their kitchen table supposed to prove a historical pattern of police misconduct across an entire department without having the power to subpoena internal police records, which they can't get because of Iqbal? It feels like a completely rigged game.
It is a profoundly difficult burden. This is where almost all pro-Scannell cases go to die. They simply cannot access the data required to prove a pattern, unless, of course, the plaintiff does something extraordinary.
Which brings us to the core of our deep dive, the blueprint Rouse used to attack this mountain. Let's look at the actual source documents, specifically Count 2 and Count 3 of his civil rights complaint. We've built up these massive walls, a 3% pro se win rate, the Iqbal standard demanding hard facts before discovery, and the Monell requirement to prove a widespread custom or deliberate indifference. How does Rouse bypass this?
Let's start with the underlying grievance regarding his public defense. Count 2 is his Monell municipal liability claim against the City of Reno, and Count 3 alleges a Sixth Amendment violation for ineffective assistance of counsel.
The facts here are startling. Rouse alleges that his court-appointed attorney, who he refers to in the documents as Loomis, did absolutely nothing for 8 months. No motions filed, no discovery requested from the prosecution.
And it gets worse. According to the complaint, at a critical arraignment hearing, the prosecutor introduced entirely uncharged, irrelevant, and inflammatory allegations against Rouse. Yes. And based on those uncharged allegations, the municipal judge doubled Rouse's bail, changed it to an all-cash requirement, and imposed strict alcohol monitoring.
And where was his appointed lawyer during all this?
The complaint alleges that Loomis, who was present in the courtroom, was completely silent.
Just stood there.
He made no objection to the uncharged allegations. He made no motion to strike. He provided absolutely no adversarial friction.
Unbelievable.
Furthermore, later at a pre-trial conference, the court verbally ordered the alcohol monitoring to be removed. But Loomis never filed the simple one-page administrative motion required to actually formalize that verbal order.
So it stayed on his record.
Yes, and because the order was never formalized, the monitoring company reported Rouse as non-compliant, which resulted in an active bench warrant being issued for his arrest.
Over a clerical error from his own lawyer.
Exactly.
So an average pro se plaintiff in this situation would sit down and write, my lawyer was terrible, he ruined my life, he violated my Sixth Amendment rights, and the city is responsible because they hired him. And as we know, that gets dismissed instantly under Iqbal and Monell.
Immediately.
But Rouse didn't do that. He produced what looks to be a masterstroke. The document is titled the RMC Appointed Contractor Docket Analysis.
This is where the meticulous preparation transcends standard litigation. Rouse recognized that he couldn't rely on discovery to find a pattern of municipal failure, so he built his own data set.
He went rogue.
Basically. According to his methodology summary, he manually searched the Reno Municipal Court's public-facing criminal records system.
The time that must have taken.
Oh, an incredible amount of time. He pulled the docket data for over 2,084 confirmed cases handled by 6 different appointed defense contractors over a 2-year period, stretching from April 2024 to April 2026.
Over 2,000 individual case dockets. He manually audited the entire municipal court's indigent defense system himself. And what did he find? Out of 2,084 cases, there were 0 jury trials. 0.
Wow.
and 0 substantive defense motions filed. Every single case in that 2-year sample that reached a disposition was resolved by either a plea deal or a warrant.
It is a staggering piece of empirical evidence. And from a legal strategy perspective, it is brilliant because of how perfectly it addresses the structural hurdles we've discussed.
Break that down for me.
Let's look at the Sixth Amendment claim first. Usually, under a landmark Supreme Court case called Strickland v. Washington, a plaintiff claiming ineffective assistance of counsel has to prove that their specific lawyer made specific unreasonable errors, and that those specific errors prejudice the outcome of their specific case.
That was a death penalty case, right, Strickland?
It was, and the Strickland standard is notoriously difficult to meet because courts are highly deferential to a lawyer's strategic choices.
Right.
However, there is a rare alternative standard established on the very same day as Strickland in a case called United States v. Cronick.
Oh, I read up on Chronic. That involved a young real estate lawyer who was appointed to defend a massively complex mail fraud case and was only given 25 days to prepare while the government had investigated it for 4.5 years.
Precisely. And in Cronick, the Supreme Court ruled that there are circumstances so egregious that prejudice is legally presumed. You don't have to prove specific errors.
Because the whole setup was flawed.
Exactly. Specifically, if there is a complete failure by counsel to subject the prosecution's case to meaningful adversarial testing, then the adversarial process itself is presumptively unreliable.
So by pulling 2,084 cases and demonstrating a literal 0.0% rate for trials and substantive motions across multiple contractors, Rouse is arguing that his situation isn't a Strickland case of one bad lawyer making a mistake. He is arguing this is a Chronick case.
Yes.
He is exposing an entire municipal system functioning with the complete and utter absence of adversarial testing.
Exactly.
Yeah.
He is arguing that the Reno Municipal Court's appointed counsel system is not actually a defense system. It is merely a plea processing mechanism. And this completely solves his Iqbal and Monell problems.
Walk me through how it solves them, just specifically.
For the Iqbal plausibility standard, he isn't making a conclusory statement that the system is broken and my lawyer was deliberately indifferent. He is providing hard, concrete, statistically impossible data.
The spreadsheets.
Yes, he gives the judge 2,084 specific factual instances to prove it. And for Monell, this docket audit is the textbook definition of a widespread practice or custom. He is demonstrating that the city's policy of contracting out defense services without any oversight or quality control has resulted in a uniform systemic constitutional failure across thousands of cases.
Wait, let me play devil's advocate here, or rather, defense attorney. Could a federal judge just look at this spreadsheet and say, hey, 2,084 plea deals isn't proof of a constitutional violation, it's just proof of a really efficient justice system where guilty people are taking reasonable plea deals?
A judge could certainly think that. And a defense attorney would absolutely argue that at trial. But you have to remember where we are in the procedural timeline. We are evaluating his chances of surviving a motion to dismiss under Rule 12b-6.
Right, the starting line.
And at the motion to dismiss stage, the court's rules are very specific. The judge is legally required to accept all of the plaintiff's well-pleaded facts as true. Furthermore, the judge is required to draw all reasonable inferences in favor of the plaintiff.
So the judge has to give Rouse the benefit of the doubt on what the data means.
Yes. A literal 0.0% trial and motion rate across over 2,000 cases over 2 years strongly infers a systemic policy of non-defense.
Wow.
It pushes the claim far past the Twombly line of being merely conceivable and directly into the realm of plausible.
Wow.
It would be incredibly difficult for the City of Reno to argue that a 0% defense rate across 6 different attorneys is just a coincidence of efficiency. At minimum, it requires discovery to figure out why that anomaly exists.
That is legitimately brilliant. He essentially weaponized the city's own public data against their Monell defense.
He did.
So the audit covers the public defense side of the lawsuit. But what about the police? Count 1 of Rouse's complaint alleges a Fourth Amendment violation, specifically that Officer Berta fabricated a probable cause report. How does he prove a Monell failure to train claim against the entire Reno Police Department without having subpoenaed their internal training manuals?
This brings us to what we might call the silver bullet of the case.
Okay.
Sometimes, a pro se plaintiff does incredible, grueling legwork to build their case. And sometimes, The universe just hands them the exact evidence they need on the evening news.
Let's talk about that breaking news out of Reno because it is frankly wild. According to our sources, on March 9th, 2026, Reno Mayor Hillary Skeeve and City Manager Jackie Bryant held a sudden press conference.
Right?
They announced that they were placing Police Chief Catherine Nance, along with 5 members of her executive command staff, on paid administrative leave.
And this wasn't framed as a routine reshuffling or a quiet reassignment. The city took drastic action. They brought in an outside agency, the Nevada Department of Public Safety, to conduct a full investigation. To maintain operations, they had to bring in Washoe County Undersheriff Corey Solferino to act as the interim chief. It was a complete, abrupt decapitation of the police department's leadership structure.
And the fallout continued. By May 12th, 2026, Chief Nance and 2 of her assistant chiefs, Miller and Elges, were officially fired. The remaining command staff were still on leave. Now, initially, the city was very tight-lipped about the reasons. They just cited vague violations of city policy. But in any scandal of this size, leaks happen. What were the actual allegations triggering this massive state investigation?
According to multiple journalistic sources, including an exclusive, detailed report from the California Globe, the Department of Public Safety investigation centers on the forgery of POST certification documents.
For you listening, what is POST?
POST stands for Peace Officer Standards and Training. Every state has a POST commission. These are the mandatory state-regulated training courses and certifications that police officers must complete to maintain their law enforcement authority.
So it's a big deal.
A huge deal. Forging these documents is a severe violation, essentially claiming officers have received critical training that they never actually attended.
And this is where the puzzle pieces snap together. What were the specific training categories that the command staff allegedly forged?
The journalistic reports specifically mentioned that the forged training records involved firearms proficiency, domestic violence intervention, and mental illness response.
Let's connect this directly back to the lawsuit. The impact on Rouse's case is staggering. If we look at count 1 of his complaint, he was arrested for domestic battery. And a crucial part of his allegation is that the complaining witness on the scene was in the midst of an acute psychological crisis.
Correct.
Rouse claims that Officer Berta violated his Fourth Amendment rights under a precedent known as Franks v. Delaware. Can you explain what a Franks violation is?
Sure. Franks v. Delaware is a 1978 Supreme Court case. It establishes that a police officer violates the Fourth Amendment if they knowingly and intentionally, or with reckless disregard for the truth, include false statements in a probable cause affidavit, or if they deliberately omit material facts that would have defeated probable cause.
And Rouse alleges that Officer Berda deliberately omitted exculpatory body cam footage showing the witness's psychological crisis and instead added legally irrelevant inflammatory sexual allegations to the report specifically to ensure Rouse was subjected to a harsher bail condition.
Exactly. And to tie this back to the city, under Monell, Rouse has to prove that the City of Reno was deliberately indifferent to training its officers properly. He has to prove the city had constructive notice that their training regarding domestic violence and mental health crises was deficient.
Okay, I have another analogy. Let's see if I can get the Monell mechanics right this time.
Let's hear it.
It's like I go to a restaurant and complain that my soup is poisoned. The manager comes out and says, "That's impossible. We have incredibly strict health and safety training protocols." But while he's saying that to me, the head chef gets arrested on the evening news for poisoning soup.
You are much closer, but let's refine it to perfectly match the legal doctrine. To fit Monell, it's more like this. You claim the chef poisoned your soup because he wasn't trained on food safety.
Right.
The city says, we train all our chefs perfectly. But then the owner of the restaurant fires the manager and the entire executive staff because they discovered the manager was systematically forging the health and safety certificates for the chefs, specifically regarding the handling of toxins.
Oh, so it's not just that the officer made a mistake, it's that the city itself acknowledges the training system was fraudulent.
Precisely. The legal impact of this news on Rouse's pleading is profound.
It's perfect timing.
It really is. Rouse doesn't have to try to survive Iqbal, so he can subpoena internal training records to prove a pattern of failure to train. The City of Reno itself fired the Chief of Police, Catherine Nance, and the top command staff for allegedly faking the exact training certifications, domestic violence, and mental illness response that are directly, factually relevant to Rouse's arrest.
It gives him an unassailable factual basis, right, in his initial complaint.
It does. When a federal judge looks at the city's inevitable motion to dismiss, they will see that Rouse is alleging a systemic failure to train officers in domestic violence and mental illness response. And they will see, cited right there in the complaint, that the city fired its own leadership for forging training documents in those specific areas during the exact time frame in question.
Checkmate.
Basically, that's the ultimate proof of constructive notice and deliberate indifference. It completely bulldozes the Iqbal plausibility barrier.
Okay, so we have laid out the immense structural hurdles of federal court, and we have analyzed Rouse's highly unique, frankly, devastating evidence. It's time to arrive at the verdict. Let's answer the core mission of this deep dive, estimating the chances this case actually gets in front of a jury.
To accurately estimate those odds, we have to look at the overall structural discipline of Rouse's filings. It's not just that he has good facts, it's that he has presented them flawlessly, avoiding the common pitfalls that doom pro se litigants.
Right.
For instance, in our source materials, there is a document titled Damages and Verdict Form Quick Reference. It's essentially his cheat sheet for the jury instructions.
What does he have on it?
He explicitly notes the difference between compensatory damages and punitive damages. Compensatory damages are meant to make the victim whole, paying for lost wages, emotional distress, etc. Punitive damages are specifically designed to punish the wrongdoer and deter future misconduct.
Okay.
On his cheat sheet, Rouse explicitly notes that punitive damages may never be awarded against a municipality.
Why is that? Why can't a city be punished?
This was established by the Supreme Court in a case called City of Newport v. Fact Concerts. The reasoning is essentially economic. If you hit a city with a massive punitive damages award, you aren't punishing the officials who committed the wrong. You are punishing the taxpayers who have to foot the bill.
Oh, that makes sense. The taxpayers shouldn't foot the bill for bad cops.
Right. And many pro se plaintiffs ruin their cases by demanding billions of dollars in punitive damages from a city. It's a legally impossible demand, and it often gets their case dismissed for failing to state a valid claim.
But Rouse doesn't do that.
Rouse completely avoids this crap. He separates his damages correctly, targeting the city only for compensatory damages and targeting the individual officers in their individual capacities for punitive damages.
I also noticed in his complaint that he mentions he spent 24 months exhausting his administrative remedies before he ever filed the lawsuit. He lists that he went through 9 different institutional oversight bodies.
Yes, that is another critical layer of structural discipline. He likely filed complaints with Internal Affairs, the Citizen Review Board, the State Bar Association regarding his attorney, the POST Commission regarding the officers, and so on.
9 of them.
Right. And by doing this over 2 years, he completely neutralizes a whole host of procedural defenses the city's lawyers might try to use. They cannot claim he filed prematurely, or that he failed to follow the proper administrative channels, or that he didn't give the city a chance to rectify the situation internally. He gave them 9 chances.
So, synthesizing all of this, the 2084 case docket audit perfectly tailors his facts to the Iqbal standard and the Monell widespread custom standard. The explosive firing of Chief Nance perfectly tailors his facts to the Monell failure to train standard. He hasn't made any rookie mistakes with his damages claims or his procedural exhaustion. So, does he actually get to stand in front of a jury and read that trial script we have in our sources?
It's the ultimate question, and the answer is a fascinating twist. He probably will not get in front of a jury, but not because he loses, because he wins.
Wait, you're saying he wins by not going to trial. Explain that logic.
Let's go back to the statistical studies. While the win rate for pro se litigants going all the way to a verdict is incredibly low, a study from the Hastings Law Journal found that 15.4% of pro se civil rights cases actually end in a settlement between the parties.
Settlement, okay.
Now, consider the massive leverage Rouse has generated. Because his complaint is so meticulously constructed, because it relies on hard data and the city's own public scandals, his chances of surviving the city's motion to dismiss are exceptionally high. He is operating far above that standard 3% baseline we discussed at the beginning.
And what happens the moment a judge denies the city's motion to dismiss?
The gates open. You enter the discovery phase. If the judge rules that Rouse's claims are plausible, Rouse gains the federal power to subpoena documents, demand internal emails, and depose city officials under oath.
Oh, wow. I see where this is going.
Think about what that reality means for the city of Reno. They are already dealing with a devastating, highly public scandal regarding the police chief's firing and a state-level investigation into forged training documents.
It's a PR nightmare.
If Rouse's case goes to discovery, he gets to legally dig into all of that. He gets to depose fired Chief Nance under oath. He gets to demand the internal communications regarding those 2,084 cases where appointed attorneys did nothing.
The city's legal department would be terrified of that information coming out in a public federal trial.
Precisely. The discovery process would be incredibly costly, highly embarrassing, and potentially politically devastating for the current city leadership. Therefore, once the federal judge validates Rouse's claims by denying the motion to dismiss, the city of Reno will face massive internal and political pressure to settle the case quickly, quietly, and comprehensively before it ever reaches a jury.
So the goal isn't a dramatic courtroom speech.
Exactly. The ultimate goal for a sophisticated plaintiff like Rouse isn't necessarily to put on a dramatic show for a jury. The goal is to engineer a legal position so undeniably strong that the city has absolutely no choice but to pay to make the risk go away.
That is incredible. So to summarize this journey, we started on those federal courthouse steps with the lone plaintiff facing an impossible statistical graveyard. We looked at the massive, intentionally constructed legal walls designed to keep citizens out by the Twombly and Iqbal plausibility standards that demand secret facts, and the Monell doctrine that demands proof of systemic municipal policies.
Yep.
And we saw how one plaintiff used nothing but sheer persistence, exhaustive public records research, and the perfectly timed implosion of the local police leadership to completely dismantle those walls.
It truly is a masterclass in how to decode and hack the legal system.
Mm-hmm.
He didn't just write an emotional complaint. He audited the system, documented the systemic failures with hard data, and applied the exact legal precedents required to force the federal court to listen.
It really makes you think about the broader implications. I want to leave you, the listener, with a final provocative thought to mull over. We've seen today that the system is largely designed, whether intentionally or just as a byproduct of complex rules, to weed out civil rights cases brought by people who cannot afford lawyers. But what does it mean for the future of municipal accountability when regular citizens armed with the internet, access to public data, and a sheer refusal to back down learn how to navigate this maze? Are we looking at the dawn of a new era of civil rights litigation where the playing field is finally leveled by information access, or will the courts just respond by building an even higher wall? Keep digging, keep questioning, and keep diving deep.